Nathaniel has been a salesman assigned by Newmark Enterprises Newmark for nearly 2 years at the Manila office of Nutrition City Incorporated, Nutrition City. He was deployed pursuant to a service agreement between Newmark and Nutrition City, the salient provisions of which were as follows. Letter A. The contractor Newmark agrees to perform and provide the client Nutrition City on a non-exclusive basis such as tasks or activities that are considered contractable under existing laws as may be needed by the client from time to time. Letter B. The contractor shall employ the necessary personnel like helpers, salesmen, and drivers who are determined by the contractor to be efficiently trained. Letter C. The client may request replacement of the contractor's personnel if quality of the desired result is not achieved. Letter D. The contractor's personnel will comply with the client's policies, rules, and regulations. And letter E. The contractor's 2 service vehicles and necessary equipment will be utilized in carrying out the provisions of this agreement. When Newmark fired Nathaniel, he filed an illegal dismissal case against the wealthier company, Nutrition City, alleging that he was a regular employee of the same. Is Nathaniel correct? Suggested answer. Yes, Nathaniel is correct. Similar to the case of Coca-Cola Bottlers Philippines Incorporated versus Ahito, GR number 179546, February 13, 2009, the lack of control by the contractor Newmark over the worker Nathaniel can be gleaned from the service agreement. It is apparent that Newmark has to comply with Nutrition City's regulations and that Nutrition City has the right to request the replacement of Newmark personnel. It is likewise apparent that the agreement did not identify the work needed to be performed and the final result to be accomplished, pointing to the conclusion that Newmark did not obligate itself to perform an identifiable job, work, or service. Nathaniel thus was under the control of Nutrition City. With respect to the service vehicles and equipment, this may not be considered as substantial capital on the part of Newmark, as the facts do not establish their sufficiency to carry out the agreement. The presence of Newmark's vehicles and equipment did not necessarily preclude the use of Nutrition City's own capital and assets. Alternative answer. Nathaniel's contention is not correct. He is not a regular employee of Nutrition but rather of Newmark Enterprises. Assuming that Newmark has a DO 174 certification, this is a valid job contracting arrangement, especially so that the Newmark has sufficient capitalization in the form of tools, equipment, machineries, and that Nutrition has no control over the manner and means by which Newmark and its employees are to do the work. Question. Sergeant Nemesis was a detachment non-commissioned officer of the Armed Forces of the Philippines in Nueva Ecija. He and some other members of his detachment sought permission from their company commander for an overnight pass to Nueva Vizcaya to settle some important matters. The company commander orally approved their request and allowed them to carry their firearms as the place they were going to was classified as a critical place. They arrived at the place past midnight, and as they were alighting from a tricycle, one of his companions accidentally dropped his rifle, which fired a single shot and in the process hit Sergeant Nemesis fatally. The shooting was purely accidental. At the time of his death, he was still legally married to Nilda but had been separated de facto from her for 17 years. For the last 15 years of his life, he was living in with Narda, with whom he has 2 minor children. Since Narda works as a kasambahay, the 2 children lived with their grandparents, who provided their daily support. Sergeant Nemesis and Narda only sent money to them every year to pay for their school tuition. Nilda and Narda, both for themselves and the latter also on behalf of her minor children, separately filed claims for compensation as a result of the death. And Sergeant Nemesis The line of duty board of the AFP declared Sergeant Nemesis' death to have been in line of duty and recommended that all benefits due to Sergeant Nemesis be given to his dependents. However, the claims were denied by the GSIS because Sergeant Nemesis was not in his workplace nor performing his duty as a soldier of the Philippine Army when he died. Letter A. Are the dependents of Sergeant Nemesis entitled to compensation as a result of his death? Suggested answer. The death of Sergeant Nemesis arose out of and in the course of his employment as a soldier on active duty in the AFP and hence compensable. The concept of a workplace cannot always be literally applied to a soldier on active duty. Sergeant Nemesis had permission to go to Nueva Vizcaya, and he and his companions had permit to carry their firearms, which they could use to defend themselves when attacked. A soldier on active duty is really on duty 24 hours a day since he can be called upon anytime by his superiors except when he is on vacation leave status, which Sergeant Nemesis was not at the time of his death. Hinugen versus ECC, GR number 8430, April 17, 1989. As between Nilda and Narda, who should be entitled to the benefits? Suggested answer. To be considered as a beneficiary, the spouse must be the legal spouse and living with the employee at the time of his death. Nilda, as the surviving spouse who has been separated de facto from the deceased employee, may still, however, be entitled if the separation was due to the covered employee's abandonment of the spouse without valid reason or for other justifiable reasons. Narda, not being a legitimate spouse, is not entitled to the benefits. However, the ECC may act as referee and arbitrator between two claimants to help each other reach a mutually acceptable compromise settlement of allocating the compensation among themselves and their dependent children. Samar Mining Company Incorporated versus WCC, GR number L-29938-39, March 31, 1971. Are the minor children entitled to the benefits considering that they were not fully dependent on Sergeant Nemesis for support? Suggested answer. Being a dependent does not mean absolute dependency for the necessities of life, but rather that the claimant looked up to and relied on the contributions of the covered employee for his means of living as determined by his position in life. One need not be in the deceased household in order to be dependent. Malati Taxica versus Del Villar, GR number L-7489, February 29, 1956. Question. Nonato had been continuously employed and deployed as a seaman who performed services that were necessary and desirable to the business of and training shipping through its local agent Narita Maritime Services Agency in accordance with the 2010 Philippine Overseas Employment Administration Standard Employment Contract 2010 POEA SEC. Nonato's last contract for 5 months expired on November 15, 2016. Nonato was then repatriated due to a finished contract. He immediately reported to the agency and complained that he had been experiencing dizziness, weakness, and difficulty in breathing. The agency referred him to Dr. Neri, who examined, treated, and prescribed him with medications. After a few months of treatment and consultations, Nonato was declared fit to resume work as a seaman. Nonato went back to the agency to ask for redeployment, but the agency rejected his application. Nonato filed an illegal dismissal case against the agency and its principal, with a claim for total disability benefits based on the ailments that he developed on board in-train shipping vessels. The claim was based on the certification of his own physician, Dr. Nunez, that he was unfit for sea duties because of his hypertension and diabetes. Letter A. Was Nonato a regular employee of N-Train Shipping? Suggested answer. No. Seafarers are considered contractual employees. They cannot be considered as regular employees under Article 280 of the Labor Code. Their employment is governed by the contracts they sign every time they are hired or rehired, and their employment is terminated when the contract expires. Their employment is contractually fixed for a certain period of time. Letter B. Can Nunato successfully claim disability benefits against N-Train Shipping and its agent Narita Maritime Services? Suggested answer: no. Nunato was repatriated due to a finished contract and not due to any accident or illness he suffered while on board N-Train's vessel. Moreover, Nunato was declared fit to work by the company designated physician. Under the 2010 POAA SEC, if a doctor appointed by the seafarer disagrees with the assessment of the company designated physician, a third doctor may be agreed upon jointly between the employer and the seafarer. The third doctor's decision shall be final and binding on both parties. In this case, no third doctor was appointed. Thus, the fit to work assessment by the company designated physician stands. Alternative explanation: no, Nunato cannot claim disability benefits. He was not medically repatriated but repatriated due to a finished contract. Although the seafarer is repatriated for completion of his contract, however, if it can be shown by substantial evidence that he acquired his illness during the term of his contract, or that his work conditions caused or at least increased the risk of contracting the disease, then his illness is compensable as it is work-connected. Malyari Magat versus Inter-Orient Maritime Enterprises Incorporated, GR number 232892, April 4, 2018. Question: your favorite relative, Tita Nilda, approaches you and seeks you for advice on her treatment of her kasambahay, Nuray. Tita Nilda shows you a document called a contract of engagement for your review. Under the contract of engagement, Nuray shall be entitled to a rest day every week, provided that she may be requested to work on a rest day if Tita Nilda should need her services that day. Tita Nilda also claims that this contract of engagement should embody all terms and conditions of Nuray's work, as the engagement of a kasambahay is a private matter and should not be regulated by the state. Letter A. Is Tita Nilda correct in saying that this is a private matter and should not be regulated by the state? Tita Nilda is incorrect. The relationship between Nilda and Nuray is an employer-employee arrangement that is regulated by the police power of the state. Through the Batas Kasambahay RA 10361, the state recognizes this employment relationship and establishes minimum labor standards for domestic workers toward decent employment and income, enhanced coverage of social protection and respect for human rights, and strengthened social dialogue. Also, since domestic workers are generally working women and vulnerable working conditions, the state regulates domestic worker employment to prevent abuse and exploitation and uphold the gender rights of domestic workers. Letter B. Is the stipulation that she may be requested to work on a rest day legal? Suggested answer: yes. Such a stipulation is legal as it states that Nuray may only be requested to work on a rest day, thereby recognizing that the consent of Nuray is needed in order to waive her right on a weekly rest day. Section 21 of the Kasambahay Law allows both the employer and the domestic worker to agree on certain arrangements to offset, waive, or accumulate rest days subject to payment of appropriate wages and benefits. Letter C. Are stay-in family drivers included under the Kasambahay Law? Suggested answer: no. Family drivers are not included under the Kasambahay Law. A kasambahay refers to any person engaged in domestic work within an employment relationship, such as but not limited to the following: general house help, nursemaid or yaya, cook, gardener, or laundry person. but shall include any person who performs domestic work only occasionally or sporadically and not on an occupational basis. Alternative answer. The Republic Act No. 10361 does not exclude family drivers from the coverage of the Kasambahay Law. It is only in the implementing rules that the family drivers were excluded. Note that the Labor Code explicitly includes family drivers and other persons in the personal service of another in the coverage of the Labor Code, and hence it is believed that the family driver should fall within the ambit of the Kasambahay Law. The exclusion of driver in the implementing rules is without basis. Domestic helper or house helper or domestic servant shall refer to any person, whether male or female, who renders services in and about the employer's house, and which services are usually necessary or desirable for the maintenance and the enjoyment thereof, the ministers exclusively to the member's comfort and enjoyment of the employer's family. Such definition covers family drivers, domestic servants, laundry women, yayas, gardeners, houseboys, and other similar house helps. Apex Mining Company Incorporated versus NLRC 196 Iskra 251 1991. Question. Nina worked as an executive assistant for Nesting, CEO of Nordic Corporation. One day, Nesting called Nina into his office and showed her lewd pictures of women in seductive poses, which Nina found offensive. Nina complained before the general manager, who in turn investigated the matter and recommended the dismissal of Nesting to the board of directors. Before the board of directors, Nesting argued that since the anti-sexual harassment law requires the existence of sexual favor, he should not be dismissed from the service since he did not ask for any sexual favor from Nina. Is Nesting correct? Suggested answer. Nesting argument on lack of sexual favor is incorrect. While his action require further proof of being a sexual favor in terms of criminal liability under RA 7877, he may still be held liable under the just causes of termination in Article 291 of the Labor Code. In Villarama versus NLRC and Golden Donuts GR number 106341, September 2, 1994, the Supreme Court held that a managerial employee is bound by more exacting work ethics with a high standard of responsibility. Sexual harassment of a subordinate amounts to moral perversity, which provides a justifiable ground for dismissal due to lack of trust and confidence. Alternative answer. Nesting is not correct. Section 3, Paragraph A in relation to Paragraph B states RA 7877. In a work-related or employment environment, it is committed when sexual harassment results in an intimidating, hostile, or offensive environment for the employee. In Philippine AULUS, Automotive United Corporation versus NLRC, GR number 124617, April 28, 2000, the Supreme Court ruled that the gravamen of the offense in sexual harassment is not the violation of the employee's sexuality, but the abuse of power by the employer. In the Rayala case, GR number 155831, February 18, 2008, a sexual harassment was said to be an imposition of misplaced superiority. The fact that no sexual favor was asked by Nesting does not mean he did not violate RA 7877. His act of showing lewd pictures to his subordinates is clearly sexual harassment. Another alternative answer, Nesting is not correct. In a work-related or employment environment, sexual harassment is committed when Nesting, who is the boss of Nina, showed her nude pictures of women in seductive poses, because said act resulted in an intimidating, hostile, or offensive environment for Nina. Section 3A, 3 RA 7877, Domingo versus Rogelio Ayrayala, GR number 155831, February 18, 2008. Question. Nicodemus was employed as a computer programming by Network Corporation, a telecommunications firm. He has been coming to work in short and sneakers in violation of the prescribed uniform policy based on company rules and regulations. The company human resources manager wrote him a letter giving him 10 days to comply with the company uniform policy. Nicodemus asserted that wearing shorts and sneakers made him more productive and cited his above-average output. When he came to work still in violation of the uniform policy, the company sent him a letter of termination of employment. Nicodemus filed an illegal dismissal case. The labor arbiter ruled in favor of Nicodemus and ordered reinstatement with back wages. Network Corporation, however, refused to reinstate him. The NLRC First Division sustained the labor arbiter's judgment. Network Corporation still refused to reinstate Nicodemus. Eventually, the Court of Appeals reversed the decision of the NLRC and ruled that the dismissal was valid. Despite the reversal, Nicodemus still filed a motion for execution with respect to his accrued back wages. Letter A. Were the legal grounds to dismiss Nicodemus from his employment? Suggested answer, yes. Nicodemus clearly committed willful disobedience of lawful orders issued by the Network Corporation with respect to the uniform policy. This is a ground for termination under Article 288A of the Labor Code. Alternative answer, the dismissal is too harsh. Doctrine may be invoked, which means the illegal dismissal case filed by Nicodemus may prosper. It may be argued that the uniform policy need not warrant dismissal as penalty for violation, as it may have no direct bearing on company operations. This is in the context of Nicodemus' above-average performance as an employee. Letter B. Should Nicodemus' motion for execution be granted? Suggested answer. In Garcia versus Philippine Airlines, the employer who did not reinstate an employee pending appeal may be held liable for the wages of the dismissed employee covering the period from the time he was ordered reinstated by the labor arbiter to the reversal of the NLRC's decision by the Court of Appeals.